The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. We are very happy to be here this morning at the University of Richmond School of Law to hear arguments in 3 cases. Before I begin, I want to thank Dean Wendy Perdue and her staff for, first of all, for inviting us, and second, for being such gracious hosts. This is a great opportunity for the court to show aspiring young law students what we do, how we do it. And hopefully this will be an enriching experience for you all, and we are going to be taking questions at the end of the arguments, and so any hard questions will go to Chief Judge Gregory and Judge Keenan and or the law clerks, because we typically, the way we operate, we get to ask the questions, not the other way around, so we're not used to answering difficult questions. So we'll begin with our first case. 22-4554, United States versus Lambour, and we've got a murderer's row of lawyers who are going to be arguing this morning. We'll begin with Mr. Wagner.
Thank you, Your Honor. And good morning. May it please the court. My name is Rob Wagner. I represent Mr. Tony Lee in this case. Also arguing today is Mr. Eric Brignac on behalf of Mr. Lambert, Mr. Gerald Zirkin for Mr. Yu, and Lana Manita for Peter Lee. I'll be addressing the issues of speedy trial violations by the district court, both under the Speedy Trial Act and the Sixth Amendment to the United States Constitution, and if time permits, sentencing concerns, primarily matters of acquitted conduct that resulted in enhancements under Guideline USSG 1B1.3c, acquitted conduct. Prior to the trial in this case, Mr. Tony Lee voiced objection after objection to the many continuances ordered by the district court in this case. He waited 2.5 years for his trial to be commenced from the first appearance in federal court. His statutory right to a speedy trial under 18 U.S.C. 3161 C1 is 70 days. The district court granted one continuance after another, never referencing the Speedy Trial Act's specific requirement of findings that the ends of justice outweigh the best interests of the public and the defendant in a speedy trial.
Can I ask you about that, Mr. Wagner? If
Sure.
the district court, and you may disagree with this, but if the district court actually made the underlying findings that would lead to a result that the ends of justice require the continuance, even if he or she did not utter those magic words, is that enough? And first of all, did that happen here? And second, would that be okay?
Well, I want to start with the first continuance that was granted in this case, Judge. And this was at JA 170 to 173. When the district court, upon the appearance of the first defendants in this case, had each of the defendants sign a speedy trial waiver. And then when Mr. Tony Lee came in several months later, he continued his case on the same basis, saying that there was good cause for his continuance on the same basis. Now, under Zedner, this is exactly what the Supreme Court prohibited under the Speedy Trial Act. That the case before Zedner was that speedy trial waivers had been signed. And the Supreme Court found that that was not sufficient under the Speedy Trial Act to justify a tolling of that act.
But Mr. Lee did not oppose some later continuances. Isn't that correct, after the trial court denied his motion to dismiss? And how do we factor that in to your argument?
Well, again, I think the Speedy Trial Act is very clear on what it requires. And this court, through Smart, Hart, Velazquez, the Supreme Court, through Zedner and Bloat, made very clear that the court, regardless of whether a defendant agrees to the continuance, waives his right to speedy trial, the district court has to put on the record the reasons for that continuance and the balancing interests that the court conducted.
But would that impact the issue of prejudice? In other words, if he agreed to some of these continuances, at least after the trial court denied its motion to dismiss, wouldn't that suggest that he did not think he was being prejudiced?
Judge, at that point in time, when Mr. Tony Lee was agreeing to continuances, there was a huge dump of discovery. And that's another issue that's come up in this case, that the matter of a request by defendants for continuances. There was a huge dump of discovery that was placed on the defendants, and all of them said that they didn't have time to review all of this discovery, so they asked the court for a continuance. I think that was the only situation under which Tony Lee actually agreed to a continuance, but at that point, he had been denied request after request to have his speedy trial rights protected. And in fact, when the judge issued its decision on his speedy trial motion, it did not provide any suggestion that that balancing of interest had been done.
I'm sorry to
Yes,
interrupt
Judge.
you, but
Sure.
I want to go back to my original question. You mentioned the waiver, but I think there's more in the record than just a waiver, right? Didn't the district court make factual findings to support, at least in his mind, the granting of the continuances? And I get your point that maybe he didn't link those findings to a legal conclusion that the interests of justice supported not finding a speedy trial violation. But that's the question I'm asking is, does the district court, is it enough to make the findings? If you disagree that the findings were made, let me know, but assuming they were made, is it your contention that the district court then needs to link that finding to a specific legal conclusion that the interest of justice supported denying the motion?
My reading of the record, Judge, and I would point the court to Joint Appendix 170 to 173, is that there were absolutely no other findings made other than the waiver of the speedy trial. Now, later on, when objections were made to the continuances and the Speedy Trial Act, rights of Mr. Tony Lee were being asserted by trial counsel, at that point, 83 days had expired from Tony Lee's first appearance in the court until the next continuance was ordered by the court. And I would suggest to the court, I'd ask you to look carefully at the record. There's nothing on the record that justifies that initial continuance. And so I think that's a very important point, Judge. I looked over the record last night just to be sure, and I saw nothing that's provided under 3161, the Speedy Trial Act, that says that this continuance is proper under the Act. Nothing there. So I point to the court's language, this court's language in Hart and Smart. And the court may exclude a period of delay if two things happen. One, if the judge granted such continuance on the basis of the findings that the ends of justice served by taking such action outweigh the best interest of the public and the defendant in a speedy trial. That's one.
Can I go back to your statement that there's nothing in the record to support factual findings? But didn't the court say first that the case was complex, right? As defined by the statute. You don't think that's a reason for granting a continuance?
Oh, absolutely. That is a reason under the Act for granting a continuance.
I think you mentioned this earlier, and he explained why the case was complex, but then he also noted, Judge O'Grady, that counsel for the other co-defendants had urged the court to allow more time for them to prepare for trial. Isn't that a reason?
I think if it's properly explained, I think that, well, I know that the statute requires that the case be so complex and so unusual that it outweighs the interests in a speedy trial.
Well, how many defendants are we talking about? You just said earlier, a moment ago, you said that there was a voluminous amount of written discovery that the defendants needed to sort through. That sounds like it's a pretty complex case.
So that was at a different point in the pretrial proceedings, Judge. Initially, Mr. Tony Lee was not concerned about the voluminous amount of discovery that was provided. He wanted his trial. He wanted to go to trial, and he asserted those rights on the record. But there came a point, I believe it was January of 2022, when the government presented just a whole bunch of new discovery, poll camera evidence, police reports, interviews with witnesses, things that the defendants claimed violated Brady. And those documents were presented to the defendants, and it was only at that point that Tony Lee said he needs more time to prepare for trial. But up until then, the Speedy Trial Act had already been violated. And it had been violated in a way that the district court showed that it really didn't understand its requirements under the law, under the Speedy Trial Act, that allowing for a waiver of speedy trial in the district court's eyes was sufficient for a continuance in the case, and didn't toll the speedy trial. But in fact, that wasn't the case, Judge. And I think that misunderstanding of the law carried through after that first continuance, when the district court failed to place the balancing test on the record or ends of justice explanations for those continuances after that point.
Can I ask you about
I'd
the
like-
Sixth Amendment? Are you going to turn to that, the Sixth Amendment?
I'd like to, Judge.
Okay, go ahead.
Yes.
Go ahead.
And so the second point here is that the district court completely failed to address the Sixth Amendment constitutional speedy trial argument of Tony Lee. The issue was briefed for the court. The Speedy Trial Act violation was briefed and decided on by the court, but the court simply missed, I would suggest, the constitutional Sixth Amendment argument. And my request to the court is that there's no other option here but to send it back to the district court for the district court to address that issue, if the Speedy Trial Act violation doesn't dismiss the charges altogether.
So about that, I get the concern. I think it certainly is legitimate, but I guess we should start with the first question. You said it was briefed, but it seemed to me to be almost an afterthought in the briefing and not really the focus of the record. Do you think it was preserved, the motion? Do you think that the defense in this case did enough to actually bring that issue to the attention of the district court?
I would concede, Chief Judge, that the briefing on the issue was not as fulsome as it could have been, but it certainly posed the question to the district court. It was responded to by the government. The government presented their arguments as to why the Sixth Amendment constitutional violation did not occur in that case, and the district court simply failed to address it. There's nothing on the record.
And if we agree with you, is there any basis by which we might come to a conclusion about the motion itself without having to send it back to the district court?
Again, I think that's outside the purview of this court. There are no factual findings on the record, nothing for you
But
to...
aren't there with respect to the Speedy Trial Act?
Sure.
And isn't there some overlap there?
There's definitely some overlap, but it does not allow this court to decisively come to a decision, a conclusion on the constitutional Speedy Trial Act, constitutional Speedy Trial Sixth Amendment violation. There's simply insufficient information on the record for this court to indulge in that kind of an analysis and that kind of a decision-making process. So our position is it must go back to the district court on that issue. And finally, Judge, I've raised the issue of a sentencing concern in this case, that at the time that the district court addressed the sentencing issues in this case, the 1B1.13c, United States Sentencing Guideline provision, was not in place. And so the district court certainly could consider acquitted conduct. And the acquitted conduct here is very significant. The firebombing charges brought against Tony Lee were acquitted, where the jury found him not guilty on those charges. Yet, the district court relied on those charges in enhancing Mr. Lee's guidelines. And this court is in a position to look at that, to decide whether or not an injustice was done to Tony Lee, and send it back to the district court so the district court can consider that particular.
Do you have a case that supports that as a standard? I mean, it seems like the law was the law at the time, and you're asking the court to say, notwithstanding that, there's been a change in the law which we should apply retroactively, but there's no basis for doing, no legal basis for doing that, is there?
I see my time has expired. My answer to the question.
Please.
This court is provided a tremendous amount
You just told me earlier we didn't have a lot of discretion with respect to it.
Well, in terms of a sentencing issue, I think the calculus is different, Judge.
Right, but the precedent was pretty clear at the time, wasn't it,
Oh,
both in this
no
court and the
question.
Supreme Court?
Judge Keenan, no question that it was. But now we're in a position where I believe under several different factors we have here, the case should be remanded to the district court. And if the court is to do that, then I would suggest that you do that on the sentencing issue as well.
Are you making it as if it's a remand request based on compassionate reasons? Because you can see that the district court at the time could enhance on acquitted conduct, correct?
Yes, exactly.
So,
And
I guess,
certainly,
in response to the Chief's question, have any precedent for that we can do that?
well, only 26 U.S.C. 2106, which allows this court to take whatever action it feels appropriate as may be just under the circumstances. And I would suggest that this issue is absolutely just under the circumstances.
Thank you very much, Mr. Wagner. Mr. Brignac, good to see you.
Thank you. Thank you, Your Honors. Eric Brignac for Mr. Lambour. I'm going to speak about the district court's denial of his motion for new counsel. And obviously, with such a short time, I very much welcome the court's questions on this. When Joseph Lambour claimed that he'd asked his counsel to file a motion for a new attorney 3 months ago, and they had not done it, the district court did nothing. It didn't even ask the lawyers who were standing right there, hey, is that true? Did that happen? No, he just said, stop. I don't want to hear it. And that wasn't any sort of adequate inquiry. It wasn't any inquiry at all. And if he had conducted the proper inquiry, he would have found a communication breakdown. We know this because Mr. Lambour had such a breakdown of communication with his counsel that he ended up almost hitting one of them during trial and ended up having to go pro se, which very much prejudiced him. I mean, he didn't have any opportunity to have a good closing argument or to have good cross-examination of the most important witnesses against him. And this isn't a case where he was trying to get delay. He wasn't a sovereign citizen who was causing all sorts of problems. This was his first attempt at trying to get a new lawyer. In the Mullen case—
Mr. Brignac, can I ask, so obviously you've done this a long time, and client satisfaction can sometimes be an issue with defendants who think that lawyers aren't looking out for their best interest, even if they might be. It seemed to me that the principal problem in this case with respect to the relationship, at least early on, was the fact that the lawyers weren't visiting the defendant enough, at least frequently enough, to satisfy him. That seemed to be one of the concerns. And so my question is, when a lawyer, separate and apart from the district court's failure to follow up on this issue when presented in court, when a lawyer is presented with a client who wants the client to file a motion for the lawyer to withdraw, is the lawyer obligated to file that motion right then and there, or is the lawyer's obligation to consult with the client to see if that relationship can be repaired?
I don't think the lawyer has an ethical obligation to file it immediately. I take your Honor's point. The lawyer, though, at that point has an obligation to follow up. And one thing Mr. Lambour said, he specifically said, you know, I continued to ask to have Mr. Yamamoto taken off my case. And the district court actually got that wrong. The district court ended up saying, you know, and you said you were satisfied. And that was, you know, when they were having this sort of final colloquy with the court, he said, Joint Appendix 735, I told him I wanted 100% put in a motion to get Mr. Yamamoto off my case because of this. And so what we know is that even if Your Honor's correct, that they didn't have an obligation to go run to CMECF and file something immediately, this was an ongoing problem for 3 months. And if you take that timeline, if you take that 3 months and go back and said, had the lawyers filed this at the time, when was that? The trial hadn't been calendared. The district court was still dealing with pretrial motions about severance. This is at Joint Appendix 84 and 85. That's a docket sheet. So that would have been adequate and plenty of time for this to happen.
Okay, well, let's assume that that was an error on the part of the district court. Is that error subject to harmless error
Yes.
analysis? And
And-
isn't the best evidence of that the performance of the lawyers at the trial?
No, Your Honor, I wouldn't say that's the best evidence. It is harmless, but I would say the difference between harmless error and plain error, or harmless error and us having to have that burden, is the government has the burden to show that the error was harmless. And when you have a situation where, again, as he alleged, I only saw 1% of my discovery, Joint Appendix 731. Joint Appendix 730, my attorneys gave me discovery, and they said, you know what, we're going to make it easy on you. We're going to mark the parts of this voluminous discovery that you're in. And Mr. Lambour started looking and saw parts of the discovery he wasn't in. Again, the level of trust. There's two questions, Your Honor, I think that are important. You have one where you say, okay, I want a new attorney because my attorney's being ineffective. And you say, I want a new attorney because we have a fundamental communication breakdown. And Your Honors know better than anyone that you sometimes ask a question and the counsel ends up giving you an answer to the much easier question. The district judge here answered the easier question. Mr. Yamamoto is an experienced attorney and I've looked at his timesheets and he's doing a great job. That wasn't the relevant question. The relevant question was the communication breakdown, and if I may just quote Judge Davis from the Smith case, only when a defendant is heard by counsel can a defendant be heard through counsel. That didn't happen here. It was a violation of the Sixth Amendment. Mr. Lambour needs a new trial.
What the basis, though, of his complaint, things that relate to ineffectiveness, like he hadn't seen me enough, he's not listening to me, as opposed to the type where we're just fundamentally, I want to go north, he wants to go south, and I don't think, those kind of things. I mean, wasn't it, because I guess the judge is saying, whatever that was, is cured because this counsel is effective. Isn't it different than you say? I know what you're saying, because sometimes one of the things, I don't care, you could be, the best lawyer in the world, but I just can't stand you, I don't want to talk to you, I think you're working for the federal government, not me, those kind of things, and lawyers know that when you get to the point where there's just no trust. But didn't they really deal with things, their effectiveness, like you haven't seen me enough to have time to be effective, and the court said, no, this is a good lawyer, and he's effective. You don't know what I'm saying?
Yeah, I do, and if I may answer. So I think, Your Honor, that the response to that is, first, it's important that he said, not just, again, he's not a sovereign citizen. He's not here saying, I hate all attorneys. I've met clients and the first thing they said to me is, oh, you're a public defender, follow the money, you're working for the government. Okay, this wasn't that situation. Mr. Lambour, when he says, I had to resort to communicating through non-incarcerated family members. My sister had to get this message to them. And then they did nothing in response to it. And as soon as he got back to court, the first time he physically was in court, he explained this to the judge. This, Your Honor, respectfully, isn't just, oh, I hate appointed lawyers, or I hate all lawyers, or that. I mean, this was someone saying, I'm having this communication breakdown, and what little we have in the record, because there was no inquiry, God, I can't say that word. There was no follow-up by the district court. What do we have in the record? We have the fact that he had to communicate through his sister, the lawyers did nothing, and it wouldn't have been hard. I'm not saying we had to have a 2-week hearing on whether he needed a new lawyer, but the judge didn't even look over at Mr. Yamamoto and say, is that true? What happened there?
Does the record provide us any basis for finding that there was prejudice as a result of that? And does the issue of prejudice matter in this context?
Well, I think, Your Honor, it is a harmless error standard. So I think prejudice does matter, although I would emphasize we don't have the burden. But I think when you're having a jury trial, and again, regardless of whether from the outside perspective, these lawyers were looking effective, whether they seemed effective, when the communication breakdown is such that Mr. Lambour says, I want to hit my attorney, I almost hit my attorney, the record, I think, was a little unclear as to whether the jury even saw that or what happened. It's crazy. And then he had to go pro se, and this poor guy, he's telling the judge, I don't need any continuance. I'm going to flip through discovery as I'm cross-examining these witnesses. This wasn't a guy trying to throw a monkey wrench into the system. This was a guy who wanted a lawyer. And where was that prejudice? The prejudice was that he didn't get the lawyer. He had, as the government said, Joint Appendix 3567, it was the most important witnesses regarding Mr. Lambour were at the end of the trial. And those were the ones he had to cross-examine himself with no training, and those were the ones that he ended up doing his closing argument, which your honors, I'm sure, have read, was a bit of a train wreck. And so I think there's your prejudice, or certainly at a minimum, that means the government can't meet its burden of showing that the error was harmless. And I know it would be a big deal to, create a whole, this was a 2-week trial, and to give Mr. Lambour a new trial is a huge deal, but it's a bigger deal to have denied him counsel. And so I would ask this court to vacate his conviction and remand for a new trial.
You want to try inquiry one more time?
No, Your Honor. This is being recorded, right? Yeah. Thank you.
Thank you very much. Mr. Zirkin?
Good morning, Your Honors. If nothing else, I guess happens today, we at least have discovered Mr. Brignac's Achilles heel. Gerald Zirkin representing Young Yu. Your Honors, we raised the insufficiency of the evidence as to counts 3, 4, 5, and 7, and the fact that the court erred in denying Mr. Yu's Rule 29 motion. Going to the kidnapping first, Your Honors, there's no evidence that Mr. Yu instigated or planned the inveiglement of Mr. White or his seizure. It wasn't his plan. He had no part. There's no evidence that he had a part in causing that to come about. It was instigated by Fahad and Saif. Mr. Yu expressed great surprise when Mr. White arrived at Loman's Plaza. That's at Joint Appendix 3103. Mr. Yu did not ride in the car with Mr. White coming to Richmond. Mr. Yu did not get Mr. White out of the car when they were in Richmond. The most that could be said is that Mr. Yu followed after the 2 other defendants who escorted Mr. White from the car to the woods and either caught up with them before they entered the woods or after, but ultimately, whichever it is, doesn't really matter. There was no evidence that Mr. Yu did anything to restrain Mr. White when they were in the woods. We know very little about what happened in the woods.
What about Richard Pack's testimony and his testimony that you stabbed White before Lambour shot him? And you're making essentially a credibility argument there, but we're not in a position to resolve a credibility issue.
I understand that, Your Honor, but as to the kidnapping, it doesn't change the kidnapping equation. It's an assault. Maybe I'll discuss it in the context of the Vicar murder in a moment, but I don't think that involves restraint. So I don't think there's any evidence that when they were in the woods, he did anything to restrain him.
And you do have to restrain somebody before you can stab them, don't you? Or at least to some degree?
I don't know that that's necessarily true. That's speculation as to how it occurred. He took the knife and he stabbed. You could stab somebody just standing there in front of them. You don't have to restrain them to do it. And we don't know what happened once they were in there. Your Honor, I would turn to the Vicar murder. Mr. White was killed by gunshots. The only evidence was that Peter Lee shot him, not that Mr. Yu did. There was evidence that, as Your Honor mentioned, that Mr. Yu stabbed Mr. White, but that did not produce fatal injury. And there was no evidence that he intended to kill Mr. White by doing that. The government must prove that Mr. Yu aided and abetting the actual killing of Mr. White, which was by the other 2 who were in the woods with him. It requires proof that he shared the specific intent to murder Mr. White. Both Fahad and Kevin Aitchison, a gang member who was present both at Loman's Plaza and Road to Richmond, thought that White was just going to be beaten up or jumped. The testimony of the government's own witness was that Mr. Yu did not want to go on missions. He didn't want to live a gangster life, that he discouraged violence among gang members, and he wanted to pay Mr. White for his injuries, not that he wanted to kill him.
Mr. Zirkin, can I go back to the kidnapping?
Yes, sir.
Offense just briefly? So this was a conspiracy, right? A kidnapping charge.
There is a conspiracy.
Underlying conspiracy.
And then there's also kidnapping resulting in death.
Okay. So with respect to are you saying that these are two separate offenses and therefore you can't consider the fact that the conspiracy charge is relevant to whether or not your client should have been convicted of kidnapping?
No, you can consider, I'm not saying that at all. I'm just saying that I would suggest that there isn't evidence to support the fact that he did anything to set up the kidnapping, to pull off the
But
kidnapping.
if he's a member of the conspiracy, isn't he in for a dime, in for a dollar?
Well, I would dispute that he's involved in the conspiracy. He is at Loman's Plaza. He expresses surprise, I would suggest, when White shows up. So he's not at that point been planning it. He's not part of the conspiracy at that point. He rides down in a separate car. They come to Richmond. That doesn't make him part of the conspiracy at that point. Mere presence, which is what he is in the other vehicle as they come to Richmond, mere presence is not enough to make either the conspiracy or the substantive charge.
All right, thank you very much.
Thank you, Judge.
Good morning, Your
Morning.
Honors. May it please the court, counsel, Lana Manita on behalf of appellant Peter Lee. I'll be addressing issues number 1 and number 5 in the jointly filed appellant's brief. Number 1 being the denial of appellant's last motion or last motions for a continuance, and number 5 being the sufficiency of the evidence against Peter Lee on counts 3, 4, 5, and 7, and the denial of his Rule 29. Firstly, we submit to the court that the denial of the joint motion for a continuance in the face of a late disclosed 632 gigabyte discovery disclosure, for which the index alone was 30 pages in length, was precisely what the Williams case speaks against, which is a denial of a continuance based on an arbitrary insistence on expeditiousness. Now, the government in its brief in opposition mentions, and the court has touched on it this morning, as has a co-appellant, that there had been past continuances in this case, a number of them. But past delays had been due to COVID and other late and large disclosures of discovery. This final request that we're discussing was made after counsel had already indicated earlier on that we needed more time, and we were given originally only 2 more weeks to go over this discovery, and it was not enough. It could not be completed, and this effectively denied Mr. Peter Lee competent counsel at the most crucial stage, the trial.
What about, the timing of this is relevant, I think, and the district court's concern, or not concern, but its reason for not willing to grant another continuance is that the lawyers were not new to the case. They had an understanding of the facts. They'd gone through a good bit of the discovery. And admittedly, this was a lot more, but it wasn't something that was in isolation. It was something that the district court felt at this point that the defense could deal with adequately. And is that, that's a reason, right, for denying the continuance. And isn't that enough how can we say that that was an abuse of discretion?
Well, it's a reason, but it was the reason that the government gave, and with all due respect to the district court, there was no way for the district court to know whether that was actually true unless we could look at all of the discovery and determine what was in there and whether it was helpful or harmful or something we hadn't seen before. And 632 gigabytes is a lot of discovery. So this district court seemed to...
Let me ask you about that. Have you pointed to anything in the discovery that you were surprised by and would have changed the result of the trial? Isn't it your burden to show that the result would have been different?
Well, and my time is up, if I may answer the question. I mean, the final version of the forensic anthropologist's report, I believe, was in this last dump, and this is only one example. The fact that we don't know and did not get eyes on everything in those 632 gigabytes is really the heart of the prejudice argument, because an unprepared attorney is per se prejudicial to a criminal defendant. That's our submission. But the one example that we know about is that the final version of the forensic anthropologist report was in there. There was not time to go through not only what this meant for the defense, but go through the practical process as a CJA attorney of justifying the funding for a forensic anthropologist. It can't be theoretical. We have to go get the approval. We have to get the author. We have to find somebody who's willing to do it. So it's not a matter of just making a phone call when we see a report in the discovery. And for Peter Lee specifically, that report, for the first time in the case, really, gave an indication of a third weapon. And that's a big deal when 3 defendants go in and there's 2 types of injury, knife and gun, and heretofore it had seemed that there had only been two weapons. So for Peter Lee specifically, that one issue was potentially groundbreaking and case changing. And there may have been other issues that we were not aware of. Unless the court has other questions, I'm over my time, but.
Thank you very much. We'll hear from the government.
Good morning, and may it please the court. Jacqueline Bashara for the United States. With me at council table is Mr. James Trump, the lead assistant U.S. attorney on this case at trial. Unless the court has a different preference this morning, I'm going to address my friend's arguments in the order that we heard them. So that means that I'm going to start first with Tony Lee's claims as to the Speedy Trial Act and the Sixth Amendment. So Chief Judge Diaz, I think you're correct that it is sufficient that the district court, at the time of each hearing where it found that it needed to continue the trial date, substantively engaged with the proper considerations for granting an ends of justice continuance, even if it didn't necessarily use the magic words, ends of justice. And it's important that those considerations mapped onto the justifications that the district court asserted in its ultimate order denying the speedy trial, the motion to dismiss. Judge Keenan, you asked about Tony Lee's failure to challenge the periods of delay that postdated the denial of his motion. And I just wanted to clarify sort of what our thinking is behind why that failure matters. It flows directly from 3162A2, which is the remedy provision under the Speedy Trial Act. First of all, it places the burden on the defendant to identify the periods of delay that he thinks did not comply with the statute. And second, it's an express waiver provision, right? It's not a forfeiture. Failure to move to dismiss waives that claim. And I think my friend said, at least in the reply brief, that this would be kind of an unworkable proposition to have defendants just renewing motions to dismiss. I want to be very clear. We're not saying that he had to just keep telling the district court, I think that continuance that you granted 2 years ago was improper. The point was that he needed to notify the district court that the continuances that the district court had not already addressed in its order denying the motion to dismiss were improper for some reason under the statute.
So Mr. Wagner says that the district court in this case wasn't really focused on the facts, the record facts that might support granting a continuance, but was instead focused, at least initially, on the fact that the defendants had waived their speedy trial rights. So can you talk to that?
Right. I don't think the record really bears that out. This is not a case like Zedner or Henry where the district court said, okay, we've got these waivers on the books and so that's good enough. Instead, I mean, if we go through each of the hearings, there was the September 2019 arraignment. The court said this fits squarely within the complex case exception, which is a specific reference to 3161H7B2. At the February 14th, 2020 status conference, again, the court reiterated substantive concerns about the number of defendants, continuing investigation, the potential for additional charges that are coming down the pipe. Pike, sorry. At the September 1st, 2020 arraignment, again, the district court said that it was concerned about counsel's ability to prepare, and right now, they're in the middle of COVID. There was difficulty because of the restrictions at the jails. Counsel had difficulty accessing their clients and reviewing the discovery that had been provided with their clients. And then again, at the April 13th, 2021 status call, the court reiterated the limited amounts of time that counsel had to prepare and to confer with their clients. So the record makes clear that the district court had more in its mind than simply some waivers that had been executed 2 or 3 years prior.
Can I ask you about the Sixth Amendment issue?
Yes.
Which I'm a little troubled by. I asked Mr. Wagner first whether it was sufficiently preserved. I didn't use those words, but it didn't seem to be the focus of the briefing. You haven't argued waiver, right, or forfeiture. What's your position?
We haven't argued that simply because, he does say Sixth Amendment in his motion, and as my friend pointed out, the government did substantively engage with the Sixth Amendment analysis in our response in opposition, so I want to acknowledge that.
Right, but the district court didn't, so
Yeah,
what are we
the better
supposed to do about
practice.
that?
I'm sorry?
What I said was you engaged, but it doesn't appear the district court did. And so you're asking us, I think, that we should do that in the first instance. And I have to say, I don't think we found a case that ever resulted in a circuit court for the first time conducting a Sixth Amendment speedy trial analysis.
And I haven't found a case like that either, Your Honor. Certainly, the better practice would have been for the district court to specifically address that claim. I don't think that a remand is necessary, first and foremost, because my friend has never said what additional fact findings we need. As I think you acknowledged during his argument, the district court's analysis of the statutory claim essentially covers the same facts that are at issue in resolving the Sixth Amendment claim. And in his reply brief, and then today, he has not argued on the merits of any of the Barker factors or said that they would shake out differently if we sent this back for the district court to do something new. And that makes sense because this court has repeatedly recognized, I think as recently as Pear, the court said that the constitutional and the statutory claims operate in tandem. And we know that because Congress enacted the statutory right to codify essentially the Sixth Amendment right. And the Speedy Trial Act is a bit more rigorous than the Sixth Amendment analysis. So if a defendant cannot make out a claim under the statute, I think it would be.
Speedy Trial Act is more important than the Sixth Amendment?
No.
What you said that?
I think I said more rigorous, just because there are those particular periods
It's
of
not more
delay.
important, but it's not more important, is it?
No, Your Honor. I
And
was
the
just,
court needs to address that, because that's what the
The district
framers
court-
put there.
I agree
They
with
put those
you.
10 things in there for a reason. We hope that they still mean, right?
Yes. All I was getting at was that I think it's a little bit more procedurally rigorous, the statute, rather than the Sixth Amendment. I agree with you, they're equally important. It would have been a better practice for the district court to address the constitutional claim here, but I submit that a remand is not necessary because the court has all of the facts necessary to resolve the claim, and ultimately, whether there's been a constitutional violation is a question of law that this court would review de novo. Unless the court has other questions about the speedy trial claims. So Tony Lee's counsel also touched briefly on the sentencing issues, specifically the district court's consideration of acquitted conduct. We laid out in our brief, the district court made alternative findings for the application of each of these enhancements, which makes clear that its calculation of the guidelines range did not necessarily depend on the consideration of acquitted conduct. Chief Judge Diaz, you're correct that at the time of sentencing, it was perfectly proper for the district court to consider acquitted conduct because the amendment removing that from the scope of 1B1.3 didn't take effect until over a year or so later. And I don't know of authority for the court to just kind of send it back, especially when there are other proper findings supporting each enhancement.
You said it was proper. Was the district court required to consider that?
Required to consider acquitted conduct?
Right.
I think it was in the court's discretion to consider that.
Well, I suppose absent a request by the government, I don't know that the district court could have reached out and done it on its own, but assume that this happened here, I guess someone made a request that acquitted conduct be considered. Could the district court have said, you know what, the record supports a finding by a preponderance that the defendant may have committed these acts, but as a matter of discretion, I'm declining to do that. Would that have been error?
I don't know that the government would have appealed that kind of finding.
Well, that's not.
I know that's not your question, Your Honor. I can't think of a case that's in that posture, so I don't think it would be error. I mean, as long as the district court kind of engages and makes a factual finding, it's up to the district court what it ultimately considers in fashioning the sentence.
Well, why would the court have to consider acquitted conduct? I thought the whole line of cases that we've, and the Supreme Court have said the district court may consider until the Sentencing Commission changed
Right, that's
the
correct.
rules, but why would the court have to consider it?
Again, I think it's a matter of discretion. If it
Yeah.
finds by a preponderance of the evidence that the facts have established here, the fire bombings. Of course, there were also 10 uncharged fire bombings which the district court also considered. And if the court were to send this back, the court, even under the new 1B1.3, could still consider the uncharged fire bombings, which outnumbered the acquitted fire bombings.
I guess your response would also be that then it would, even if the district court could decline to consider acquitted conduct, it would be the defendant's burden to show abuse of discretion in failing to discount acquitted conduct.
I think that's correct, Your Honor.
Okay.
I can move next to Mr. Lambourne's request for new counsel. So I want to start out by kind of clarifying where the record stood when the district court made its decision. My friend suggested that the district court failed to actually confirm with defense counsel the verity of the defendant's claim. But if we look at the first statement during the hearing is from Lambourne's attorney, Mr. Broadnax, who told the district court, Mr. Lambourne had in previous occasions intimated that he was not happy with our services and requested on Friday of last week very definitively that we ask to withdraw. And then the district court turns to Mr. Lambourne and asks him to explain his concerns with his counsel. And Mr. Lambourne says that what he said, referring to Mr. Broadnax, what he said was true earlier. I asked last Friday for this motion, but I actually asked 3 months before when I was in Northern Neck. And then he goes on and describes this exchange between Mr. Broadnax and Mr. Lambourne's sister, in which Mr. Lambourne says that he told his sister to ask his attorneys to withdraw. And then Mr. Broadnax started visiting him, but Mr. Lambourne, I guess, was not satisfied with the amount of discovery that they were going over. Mr. Broadnax told him the most important discovery is coming 40 days before trial. And this is important then. So Mr. Lambourne, in his colloquy with the district court, so I said, okay. But I still wanted, as my colleague alluded to, I told him I wanted 100% put in a motion to get Mr. Yamamoto off of my case. So then, based on this, his attorney's statements and then Mr. Lambourne's statements, the district court found that Mr. Lambourne made conflicting statements about when he asked his attorneys to withdraw and then the fact that he actually decided to wait after initially suggesting that they withdraw. So on that record, I don't think you can say that the district court clearly erred in finding that the motion that was filed 6 days before trial was untimely.
If we disagree with you, I guess the question is, what do we do about it in the context of the record? And your position, I suppose, is that the record is the best evidence of the lack of any harm or prejudice to the defendant.
I agree with you, and Before we turn to the harmlessness, if I could just make the point that the district court actually found that there was no attorney-client conflict and no lack of communication. And those were the primary reasons why the district court denied the motion. This court has recognized in cases like Smith that if there's a meritorious claim, even a lack of timeliness is not going to defeat that. So I think even if Mr. Lambour had filed his motion 3 months before trial when he says that he wanted to, it still would not have been an abuse of discretion for the district court to deny the motion based on the record in which it found that there was no breakdown in the attorney-client relationship. That's the essence of the request for new counsel. That's why the inquiry is driving at the defendant's concerns. What is the nature of the relationship that exists at the time? And I would reiterate.
Did the lawyer say that there was no breakdown? Did the lawyer say there was no breakdown? His lawyer. Did the lawyer say there was no breakdown? That was the best evidence, isn't it?
The lawyer did not say that. The district court did not ask that question, but the district court made a finding.
Right, well, make the finding, but you didn't ask the question. How you're saying it should be sanguine that there was no conflict. Well, the lawyer didn't say that. The lawyer didn't say, oh, no, we get along fine. What contradicted in the record that there was a breakdown?
If I could point you to 3 points in the colloquy that suggest that they were continuing to communicate, I think that's probably the best evidence in the record. First off, Mr. Broadnax confirmed, so Mr. Lambour brought up his concerns that these problematic statements that he made after the reverse proffer, he was worried that those would come in as evidence against him at trial. And the district court specifically addressed Mr. Lambour's attorney, who confirmed that he had spoken with Mr. Trump, who confirmed that those post-proffer statements were not going to come in at trial. So clearly that shows that Mr. Lambour was talking to his attorney about this concern about the evidence that was going to come in against him. Second, when Mr. Lambour said one of the things that he wanted to be able to do was to subpoena the deputy of the jail to support his possible alibi defense, again, the district court turned to defense counsel and said, has he asked you about this? And the district court confirmed that Mr. Lambour had told at least Mr. Broadnax about this possible subpoenaing of the deputy of the jail. And then third.
So that's the end of that? You're admitting that you did ask about supporting an alibi, and the court said that was fine. How was that resolved? How was it resolved when that was brought up as part of the reason for his being dissatisfied? I mean, you're saying that the court said there's nothing here, nothing there. How was that resolved? Because you have a person standing there before the court and a lawyer, and he's saying there's a problem. And you say, oh, this is resolved. Didn't he say he went almost a year or something and didn't? Am I wrong about that? Hell of what? I mean, wasn't there several things he was complaining about over time in terms of discovery?
Yes.
And those kind of things. How did the court just resolve this by standing up there and say, no, you're wrong? And how was that resolved?
Okay.
Factually. In terms of fact inquiry, because, Sixth Amendment right to counsel, I mean, people just ignore, the Constitution. I mean, the framers said that was important, effective counsel, and it was resolved just because, well, no, I think your lawyer's good. The delay was fine, the alibi was that, and you said it just pass on and then go to the next one. Is that the way we should adjudicate these cases at the appellate level?
I don't think so, Your Honor. The point I was trying to make was just that it was clear that Mr. Lambour was telling his attorneys what he wanted them to do. But to address your question about kind of how the district court unpacked the complaints that Mr. Lambour raised, the district court heard him out for several pages of transcript and then said, I hear you, but these are the same concerns that all defendants are experiencing right now. A lot of the problems in terms of the insufficiently frequent visits and maybe lack of reviewing enough discovery stemmed from the COVID-19 protocols at the jails, which uniformly restricted counsel's access to their clients. There was also the fact that most of the discovery produced in this case was subject to a protective order because of the nature of the charges here, and so the counsel could not simply leave the discovery with his client. So, and those are what the district court substantively engaged with and found Basically, these are concerns about lack of access, but there is no breakdown in the attorney-client relationship, no breakdown in communication, no kind of intractable conflict that would prevent an adequate defense. Chief Judge Diaz, I do agree, though, that if the court is maybe iffy on the timeliness finding, you could still say that any error here was harmless, given the adequate assistance that his counsel rendered through the majority of the trial. And so my friend, I think he said in his reply that he's not raising some challenge to the effectiveness of Lambourne's performance after he decided to go pro se. He's also not challenging the Feretta colloquy, I don't think. And so if you look at cases like Horton, that involved a similar fact pattern where the defendant before trial had moved for new counsel, the district court denied that motion, the defendant went to trial, he was convicted, and sometime after trial but before sentencing, the relationship really did break down and he had to replace his counsel, and the court said, be that as it may, that doesn't show that any error in denying the motion at the time was harmful. And I think the same bears out here. There was 3 weeks that elapsed between that hearing on his motion and then the 12th day of trial when he decided to go pro se. And so that doesn't, the fact that over the course of trial, I'm sure that hearing all of the witness testimony, trial can be taxing for everyone involved, that the relationship subsequently did break down doesn't mean that any error in denying the pretrial motion was harmful.
So before you turn to the next issues, you're suggesting that we should sort of cabin the analysis and not look at what happened near the end of the trial, where, as you point out, the dissatisfaction became clear, in fact, so clear that there's evidence that the defendant attempted to assault his lawyer. That's pretty good evidence that he was unhappy.
I agree with you, and I think it's clear that the relationship did break down by the 12th day of trial. I would just submit that that doesn't mean that the district court abused its discretion or that any error harmed the defendant at the time that the district court made its ruling based on what it was hearing from the defendant and his ability to communicate with his counsel. The next issue, Mr. Yu challenged the sufficiency of the evidence. Just given the time that I have, unless the court has specific questions as to sufficiency, we could rest on our briefs so that I can move on to the next issue.
So about that, Mr. Zirkin talked about the things that his client did not do with respect to the kidnapping offense, the things that he wasn't involved in. But is that the analysis, or is it the sort of the overall nature of the conspiracy to commit the offense?
So if you view the evidence in the light most favorable to the government, I think there was overwhelming evidence that you participated in the conspiracy and the kidnapping. From the outset, you threatened Mr. White and threatened to put a bounty on his head. Other members of the gang knew about the debt and offered to help locate him for Mr. Yu. When Mr. Nguyen was in the car with White and this was all unfolding, he called Yu to kind of give him the approval to assault Mr. White. And then Yu is the one who was paying for Nguyen's attorney. And then Nguyen's attorney was keeping Mr. Yu involved about the status of the state case. And then if we turn closer to the actual kidnapping, so there was testimony that Sung Park heard Mr. Yu and Mr. Lambour talking about going on a mission. This was on the night of January 31st, 2019, the night of the kidnapping, before they left for Peter's apartment. Peter's apartment is where everyone met up. And at Peter's apartment, Peter and Yu told Aegisan and Carlisle that Fahad was gonna set up Brandon White because he owed Mr. Yu money. So Mr. Peter Lee and Mr. Yu described this plan where they were going to drive these two cars and meet up at Loman's Plaza near the McDonald's. Then there's surveillance footage showing the two cars that are parked directly adjacent to each other. And Yu is standing there kind of as they wrestle Mr. White into the cars, and then they drove down to Richmond together. And when they lost sight of the other car that had Mr. White in it, Yu told Fahad to call Peter so that they could meet up. So all of that goes to show that they were operating in tandem throughout, and he certainly was a willing participant in the kidnapping conspiracy.
Okay?
All right, the final issue raised by Peter Lee was regarding the district court's denial of the additional continuance in the 4 days before trial. The defendant needs to show that the denial was unreasoning and arbitrary. On this record, I would submit that it's not. Chief Judge Diaz, you acknowledged in my friend's argument that the lawyers were not new to the case. They had been assigned or working on it at least 2 years at that point. As the district court observed, these were veteran lawyers in our district who regularly handled these complex racketeering and murder cases. I also just wanted to highlight that the government had been producing discovery on an ongoing basis. My friend characterized the discovery as being late. That's not correct. The district court never found that we violated any rule or any order or any of our discovery obligations. We complied with all of them. And there was also no finding of any kind of bad faith on the part of the government.
I understood counsel's argument to be, and all of that, I think of what you said is true, that they were veteran lawyers, the government complied with the scheduling order, but that the amount of new discovery that came in right under the wire, it was just unreasonable for the district court to conclude that these veteran lawyers could get through all of it in time to adequately prepare for trial.
Right, so when the new discovery was produced in February, that's when the district court actually granted an additional continuance after engaging with the coordinating discovery attorney, which this court specifically authorized to help the defendants process and be able to search through all of the discovery. After hearing from the coordinating discovery attorney, the district court gathered more information about how long it would take for that attorney to process the new material in a format that would be searchable for defense counsel. And she projected that it would take her 3 weeks. So that's why the district court gave defense counsel the additional 2 weeks in which to review the additional discovery. It was searchable across file types, which is critical because that way they could just type in a keyword or a name and find information specific to a particular witness or area of testimony. And so the defendants actually started receiving discovery as far back as August 2019. They had the assistance of the coordinating discovery attorney by September of 2020, and then the defense counsel received the bulk of the discovery in this case by December of 2020. I also just want to remind the court that there were 7 attorneys on the defense team in addition to the coordinating discovery attorney who were preparing for trial. There were actually 9 defense attorneys at the time of the February 2022 productions. There were 2 defendants who pleaded guilty very close to trial. So it was a fairly robust team of lawyers who were reviewing the material and preparing for the case. And one concern that we haven't talked about, but it was relevant to the district court's balancing and whether the court abused its discretion, were the justifiable concerns for the safety of our witnesses. That's something that the district court specifically expressed as a reason in its order denying an additional continuance. That's a substantively valid concern this court has recognized in cases like Fuller. And unfortunately, that concern materialized on the very first day of trial when Tony Lee called his associate from the jail and had them post on Instagram, "Watch the snitches snitching this week," and shared the government's first day witnesses. So the district court had to balance, once the information about the cooperating witnesses, sort of the cat was out of the bag, the district court had to balance the defendant's amount of time that they had already had to prepare for trial against the concerns of putting our witnesses at risk by having this information lingering out there. But ultimately, even if this court were inclined to conclude that the district court abused its discretion, the defendants have failed to show any specific prejudice. I think the one point that my friend focused on was on the forensic anthropologist's report. But at trial, Peter Lee's counsel cross-examined her extensively and actually identified a discrepancy between the forensic anthropologist's testimony regarding the number of gunshot wounds and what was reflected in the report. And as we noted in our brief, I mean, there was simply overwhelming evidence of Mr. White's injuries. I don't think anyone disputed that he was killed, that he died, and ultimately, it was not the forensic anthropologist's province to render an opinion on the cause of death. Only the medical examiner, who was a medical doctor, could do that. And that, I mean, the defendant has never challenged sort of his ability to engage and cross-examine the medical examiner. Unless the court has further questions,
Thank you very much.
we ask that you affirm. Thank you.
Mr. Wagner?
Thank you, Your Honor, and may it please the court. Judge, turning to the initial continuance that we've been discussing during this argument, and I point the court again to the transcript of the trial. The district court was much more concerned with the calendar and the schedules of the court and of counsel, much more concerned with getting waivers from each of the defendants rather than setting forth any justification for the continuance under the Speedy Trial Act. And at 172, you see the judge colloquy, Joint Appendix 172, you see the judge colloquy each of the defendants in court asking if they waive their right to the speedy trial. And you see there also that the only justification given, and this is at line 6, because of a need to prepare for trial and also their own calendars and the court's calendar. And so there you see no justification for this being a complex case. You see no justification for there being an abundance of discovery in this case, merely a waiver of speedy trial. And then you go to page 273 of the Joint Appendix, and that's when Tony Lee is first brought in, and basically the judge relies on the same justification for the other defendants in continuing Tony Lee's case at that point for 83 days. I would quote from Zedner. In Zedner, the Supreme Court specifically stated, a straightforward reading of these provisions, the provisions of the Speedy Trial Act, leads to the conclusion that if a judge fails to make the requisite findings regarding the need for an ends of justice continuance, the delay resulting from the continuance must be counted. And if as a result, the trial does not begin on time, the indictment or information must be dismissed. Now, turning to the Sixth Amendment constitutional issue, I just want to make clear that counsel for Mr. Tony Lee at trial identified that the prejudice by denying that constitutional challenge was the ability to identify, locate, and interview witnesses. So there was a prejudice prong that was provided by counsel to the court.
Was that a generic statement? Did he identify particular, did he identify particular witnesses?
He did not. He did not.
That's not enough then, I don't think.
Well, I would suggest that it satisfies the prejudice prong, at least to the extent that the district court should have been compelled to issue an opinion on that and to provide some answer.
Well, I think
to
the opinion would have
question.
been, that's not enough.
That would be speculation. And the district court had lived this case for a number of years at that point and had context as to what was going on with all of the witnesses in the case, all of the counsel in the case, all of the defendants in the case.
All right, thank you, sir.
And finally, if I could. Very briefly, under 1B 1.3 of the guidelines, as far as acquitted conduct is concerned, the changes in the sentencing law between the sentencing of this case and the appeal here, I would say, provides justification for this court to remand the case back. It's a compelling circumstance, remand this case back to the district court for resentencing.
Thank you very much.
Thank you. You had asked Judge Diaz, and the government pointed out about, did lawyers have to file this motion as soon as he told them? The Mullen case is very important. We talk about it in our briefs. It shows there, it was not the defendant's fault. The timeliness review is for the defendant's fault. There, it was the fault of the court for not calendaring it, wasn't held against him. So first step, it was timely. The adequacy of the district court looking into it, as you pointed out, Judge Gregory, he didn't even ask, was there a breakdown in communication? Maybe an analogy to Matthews v. Eldridge, what level, the district court did nothing. And so the question of what would have been adequate enough, we don't really get to, because whatever it did certainly wasn't enough. I also want to point the court to Joint Appendix 3238, when we're talking about what he could have done. Quote, he's talking to the court, "I did not know that I could write to you about these issues. I had no knowledge of that. I have told my lawyer, who is the one I'm thinking is the one who controls these things and these motions." Yeah, that was right for him to think of that. And my red light's already on, so I will, if I may just conclude, these lawyers were not advocating for Mr. Lambour, they were managing Mr. Lambour. And as a defense lawyer, I can't stand for that, and I don't think this court should either.
Thank you very much.
Thank you.
Your Honors, counsel, I believe, mentioned the fact that other members of this group made offers to take care of Mr. White for Mr. Yu, but Mr. Yu didn't take them up on any of those offers. All of that actually goes to the fact that he wasn't interested in killing Mr. White. He never indicated he was interested in killing Mr. White. And nothing indicated that Mr. Yu knew that Peter Lee's or Mr. Lambour's intent was to kill White before they went into the woods, nor that he became aware of that intent while in the woods before they shot him. We don't even know when they formed that intent. For all we know, something happened in the woods that caused one of them to decide to kill White rather than simply to beat him up. And since there's no evidence as to the details of what had happened in the woods, it cannot be concluded that you learned of the intent to kill in time to withdraw, which is what Rosemont requires. Thank you.
Thank you very much, Mr. Zirkin. Oh, there's a 0 next to your name, sorry. So I want to thank all the lawyers in this case for their very able arguments this morning. Generally when we see 4 defense lawyers on one side of a table on an appeal, it doesn't work out well, but it did here, I think, because you all ably prepared and I think represented your clients in their very best interests. And so I want to thank all 4 of you, and I'll come back to you in a second. I also want to thank the government, Ms. Jar, for your able argument. I wanted to say a few words before we come down and greet counsel about the state of affairs in our judiciary, and particularly the budget issues that have roiled the judiciary and the defender services for some time. For those of you who don't know, over 90% of defendants in our criminal justice system are indigent, meaning that they can't afford to pay for the services of a lawyer. When that happens, the federal defenders, the very able federal defenders, represent roughly about 60% of the defendants who are in that position across the country. The other 40% are represented by lawyers like Mr. Wagner, Mrs. Zirkin, and Ms. Manita, who take these cases on as part of their practice and are paid by the federal government. Unfortunately, since July of this year, these lawyers have not been paid for their work. And given the current budget situation, which is, if you at all familiar with the recent news, is only getting worse and more dire, it's not clear to me when, if at all, any of these lawyers will be paid, which frankly is an abomination as far as I'm concerned. It's just a terrible situation in which to be in. And then on top of that, if we have a government shutdown at the end of the month, which I suspect, unless there's some Hail Mary miracle that I don't see coming, then the U.S. attorneys will not be paid, the federal defenders will not be paid, judiciary staff will not be paid. And this is just a horrific situation in which we find ourselves. And of course, there are larger budgetary issues that the federal government is dealing with. So I would urge those of you in the audience to please speak with your representatives about this situation and let your voices be heard. We are doing all we can from our perch to try to remedy the situation, but it's just not clear to me that our voices are being heard. And our system can't work without lawyers who are willing to take on these cases, like these very able lawyers here today. Many of them are going to walk away from this work if they can't have no realistic opportunity of being paid. And that would be disastrous for our criminal justice system. So I want to thank all four of you for taking on this important work and being court appointed for this appeal, and for ably representing the interests of your clients. And my hope is that at some point you'll get paid, but more importantly, thank you nonetheless for doing it, even without the prospect of getting paid anytime soon. We'll come down and greet the lawyers and then move on to our second case. Are you okay, Roger? Please be seated. Our second case is 23-4701, United States versus Celadon. Mr. Bryant.
Thank you. Good morning. May it please the court. My name is Patrick Bryant, and along with my co-counsel, Amy Austin, I represent the appellant Francisco Celadon in this appeal. At Mr. Celadon's supervised release revocation hearing, the district court committed procedural error by failing to address counsel's non-frivolous mitigating arguments for a shorter sentence than the statutory maximum sentence that the court ultimately imposed. Mr. Celadon made arguments that were specific to the revocation context in light of the 10-year sentence that the court had just imposed on the new criminal case. The district court failed to address any of them or explain why it was rejecting them. This court requires district courts to provide a thorough explanation for their sentences. But to the extent the court did offer any explanation, it relied on factors that are excluded from consideration in the revocation context. And for that reason, this court should vacate the sentence and remand for a new hearing. Turning first to counsel's specific arguments that the district court did not address. First, and these start on page 47 of the appendix, counsel argued that 10 years was a sufficient sentence for the entire range of conduct, and that at that point in the proceedings, the parties knew that that was the sentence that Mr. Celadon had received in the new criminal case, and so counsel were able to shape their arguments in light of that sentence. And counsel said that 10 years was enough, particularly because that was higher than what the guidelines would have been had the mandatory minimum not applied. So it was already an elevated sentence, and therefore additional prison time for the revocation wasn't necessary. The court didn't specifically address that. Second, counsel argued that punishment was not a factor that the district court could consider in the revocation proceeding. And that's something that this court had already held, and then the Supreme Court has since confirmed in the Asteris case. And then third, counsel argued that because Mr. Celadon was not a citizen and would be deported at the end of his sentence, he would not have access in the Bureau of Prisons to certain programs that would allow him to shorten his sentence. He certainly would not be eligible for a halfway house or home detention at the end of his prison sentence. And so therefore, the time that he would serve would be longer and harsher than someone who committed an identical offense but was a citizen. And the district court didn't address that either.
Thank you for that, Mr. Bryant. So is it your position that the court needed to tick through each one of those factors and explain why they didn't persuade him to not impose the sentence that ultimately was imposed in this case?
I think that's this court's holdings, yes, that
Well, I thought the cases say that a district court judge isn't required to robotically tick through the relevant factors, and part of that is the arguments that the lawyer is making. And just to make the point, the additional point, you're right, the district court didn't identify each one by the chapter and verse, but he did say, and I'm looking at page 50 of the joint appendix, he said, Mr. Celadon, in a typical case, this court would find your attorney's presentation to be very, very compelling. Isn't that an acknowledgement that he understood those arguments, or at least acknowledged them?
I don't think that's sufficient. I think at most, that's simply saying, I've heard what your counsel has said. And I don't think that's any different than saying in a case that I've considered the statutory factors, which this court has said isn't enough. And so I'm not saying that the district court has to repeat word for word and parrot back what the counsel has said. And I think the phrase that this court has used in some cases is the central thesis. But when we're talking about non-frivolous arguments that are directly relevant to the length of the sentence, particularly in light of what had just gone on, the court has to at least acknowledge, I've heard that, and explain not just that I've heard it, but why it's not compelling.
Well, go ahead. No, actually, go ahead.
But when you read the judge's comments, he's really concerned about the massive breach of trust here. That you had the prior offense, what was it, in Alabama? Mm-hmm. And then, you know, the defendant had been required to serve time. And then he goes out and you have a huge amount of cocaine, which I would argue is probably relevant to the breach of trust, isn't it? So it wasn't the court looking at the amount of cocaine in terms of the egregiousness of the crime he committed, which we can't do. He was sentenced on that separately. But the court can look at the breach of trust and the degree to which the defendant breached the trust. And that's what bothers me about this case, because when you read what Judge Hudson was saying throughout the transcript, he really seems concerned this defendant did not learn. And he was given an opportunity and in a major way pretty much thumbed his nose at the judicial system. So how do you answer that?
Well, I understand that concern. I have three responses to that. One is that I don't think we can parse out from this transcript that clearly how much of this was a reference to a breach of trust versus the seriousness of the offense. And I think that the statements could very well be read to be a reference to the amount of drugs and treating that as a seriousness factor, which is something that is out of bounds for consideration in this context. So that's one. Second, in the Asteris case, the Supreme Court specifically reserved at footnote 5 whether breach of trust is even a relevant consideration, and said we're not going to get into that, but at least pose the question that breach of trust might not even be something that the statute will.
I think you have to concede that our case law says that is something the court is allowed to consider.
I understand, and that's certainly in the guidelines, but it is at least an open question, and if this court says that breach of trust is all that we have here, then maybe you've given us a cert petition on that issue, because the Supreme Court is at least open to it. But the final thing I want to mention about the breach of trust is, I think it was already adequately taken into account by virtue of the fact that there is a revocation proceeding and a revocation guideline of 12 to 18 months. And so if the court was concerned about it and then goes 2 to 3 times above the guideline range to impose the statutory maximum of 36-month sentence, I think it was incumbent on the court to explain, even conceding there was a breach of trust and even conceding that that's something the court could consider, why it was such an egregious breach of trust that not even 18 months was sufficient. And so I think particularly
I'm sorry to interrupt.
No, please.
That almost sounds like you're moving into an argument about substantive reasonableness, because let me ask you, I'll ask you point blank. If the court had ticked through all of those factors and said the points you highlighted earlier, and said, I understand those arguments, they are compelling in the abstract, but for the reasons that Judge Keenan highlighted about the amount of drugs involved and the fact that he had done this once before and did it yet again, I think an appropriate sentence in this case is the one that he landed on. It sounds like you're making the argument that there would be no justification, because there's nothing else that I can see in the record that the judge could have pointed to beyond what he pointed to for justifying his sentence.
Well, I'll acknowledge that sometimes the distinction between procedural and substantive reasonableness can be a little fuzzy. And sometimes there's overlap in those considerations. We haven't specifically made that argument because I think the procedural reasonableness is an antecedent consideration for this court. And so I think when we get into that sort of speculation that if the court had gone through these steps, maybe it would have ended up in the same place, then we're engaging in the guesswork that is not really the province of this court.
Well, the government would say that that's an analysis with respect to harm and harmlessness. Isn't that relevant?
I think that is something that can be considered, but it's also notable that at the sentencing in the new criminal case, at the end of the proceeding, the court said that I would impose the same sentence regardless, even if there were any errors in the guideline, which is a confusing thing to say at that point because there was no dispute about the guideline. But I think that indicated that the court thought that 10 years was the appropriate sentence in that case, regardless of the guideline or the mandatory minimum. But the court didn't say that in the revocation context. And so I think we can't presume that the court would come out exactly the same way if it had to go through and address specifically why those arguments weren't sufficient, especially if the court made very clear it was not considering the punishment factors. And here the court did. The court used phrases like the seriousness of the offense, and the court used on page 53 of the appendix, that's the price you pay for it. That sounds like retribution. That sounds like I'm punishing you, you're paying the price. And maybe there's another way that somebody could read that or construe that sentence, but I think the most obvious construction of it is punishment and retribution. And so if the court...
Don't you think, though, and I don't mean to interrupt you
No,
here,
please.
but You know, I understand your breach of trust concern because it's kind of threading the needle a little bit in terms of acknowledging the need to avoid reference of punishment per se for the offense that occurred prior, not the earlier one.
No, I
but-
understand.
But here then, we have a situation where, as Judge Diaz said, there's not much else in the record. So you're saying, your argument essentially comes down to do it right. Isn't that pretty much what you're saying to us, that we can glean perhaps what the judge intended? And it's pretty obvious, at least to my mind. And in fact, I told one of my law clerks, I took the bar exam with the trial judge in this case. I'm very familiar with him. But when you have a situation when the record speaks very clearly what was concerning the trial judge, vis-a-vis whether the trial judge actually did it right, where does that leave us?
Well, I think process
in terms
matters.
of the case law?
I think process matters, and I think this court has been very clear, even in the revocation context, where the circuit court is more deferential to district judges. But Thompson, Slappy, Gibbs, Patterson, all of those are cited in the briefs, and all of those are revocation cases where this court found fault with the district court's procedure. And so I will acknowledge this is an experienced judge, and we were experienced lawyers in the case. Mr. Celadon is the one who doesn't have as much experience, and he's the one that it really matters if he hears it from the judge's lips. And,
Well, Judge Hudson would have said that your client had experience, and that's why he's in the position that he found himself.
He didn't have experience in the revocation context, and supervised release is a bit of a weird animal to understand, even for people who have a little bit of experience. And Mr. Celadon is not a career criminal. He has had run-ins with the law in the past, including what got us here to begin with, but he doesn't have a tremendously extensive criminal history, and so.
But he makes his living dealing massive amounts of drugs.
I don't think the record supports that he's anything more than an occasional courier.
Well, did the record show the value of 13 pounds of cocaine?
It was a significant amount, but we don't know how much he got out of that. But at a minimum, yes, I think process matters. I think it's important for defendants at the end of the day, if they have to turn to their lawyer and say, why did he give me the maximum? The defendant deserves to hear that from the court. And so that's why we don't think it was sufficient here. And if we've had to spend all this time speculating and guessing and surmising about what the court must have thought, then there's been a failing, and we shouldn't have to do that. It should go back for the court to specifically address it, and again, specifically address it without reference to the forbidden factors. If there are no other questions at this point, I can reserve the remainder of my time for rebuttal.
All right. Thank you, Mr. Bryant. Mr. Gibbons?
Good morning, Your Honors. May it please the court. My name is Shay Gibbons, and I proudly represent the United States of America in this case. There are three reasons why the court should affirm the revocation sentence imposed by Judge Hudson in this case. First, the sentence was procedurally reasonable because the district court considered the appropriate policy statements in Chapter 7 of the Sentencing Guidelines Manual. He considered the relevant 3553A factors, and then he addressed the defendant's non-frivolous arguments and explained why he rejected them. As Your Honors mentioned, he said that in another case, he would find them very, very compelling. But here, his overriding considerations were the breach of trust committed by the defendant.
But he didn't substantively address the arguments.
That's correct.
That were just referenced by Mr. Bryant.
That's
He didn't
correct.
substantively address that he had, was ineligible for certain considerations because he was subject to removal. The fact that he was 47 years old and would be 57 when out of the penitentiary. These are not frivolous arguments, and I understand the government's position because, as I said in my question earlier, the record is really clear that the judge was concerned about a breach of trust. But what do? I mean, why wouldn't we just say to the trial judge, you know, you have to answer the non-frivolous arguments. We said it before in our case law, and just do it right.
Yes, Your Honor. So we believe the judge did comply with these course precedents for two reasons. First of all, he did address the central thesis of the defendant's arguments, which were the arguments that the defense attorney made in the original sentencing. And that was about the quantity of the drugs and the coercion, the alleged coercion of Mr. Celadon participating in this courier activity. There were some revocation-specific arguments that the court heard right after the defense made those arguments. That's when the judge said on Joint Appendix 50, otherwise, I would find your attorney's arguments to be very, very compelling. But again, going back to his overriding two considerations. This court in Slappy said that the district judge either needs to mention a party's non-frivolous arguments or where the court provides a reason for why the judge rejected those arguments. And that's exactly what Judge Hudson did here.
But
He
counsel,
said,
don't we have to be careful when we talk about breach of trust? Isn't that always a question in revocation?
yes, Your Honor, it is always.
So why does that make this not typical?
Excuse
Why
me?
why is it, because what he talked about financial hardship of his family, to take care of his family. He had fear of what reprisal, the cartel. He had a small role as a courier. And the court acknowledged that these things would be persuasive if this was not typical. Okay, the typical part is the breach of trust. In all cases of revocation, correct?
Yes,
You
Your
wouldn't be there if you had not done something that breached the trust that said that we're gonna let you on, right? So what did the court address to put this over the top to the point that I can put aside those non-frivolous reasons here? And just by saying, this is not typical. But it is typical. The other part is the retribution part that she's not supposed to use may be the part that when you're talking about is not typical, but it's certainly not, doesn't make it not typical just because you breach trust. And these were some pretty substantial non-frivolous reasons. I mean, financial, I know it shouldn't be a reason, but it's one thing somebody has everything in the world and all their assets and that kind of thing, they go out and commit crime. There's another, someone who had to put food on their family's table. Not justified, but that's, or somebody's afraid of what's retribution to them and they had a small role as a courier. Oh, how is that all put aside just because by saying, this is not typical? Breach of trust is typical. It's every revocation case has breach of trust. So what in this record was not typical that would cause you to just give max time, not even consider anything less than that in this record?
Yes, Your Honor, and I believe the district judge was very clear about that. So as we indicated in the brief and as the policy statements in Chapter 7 indicate, it's very easy to get a grade
No,
A.
follow me. You're about to say what the judge did. I want to hear what I know what the statute says. What did the judge do?
Yes, Your Honor. So he was, as Judge Keenan has mentioned repeatedly, he was overwhelmingly concerned with these two factors. And immediately after citing those two factors, and he says when imposing the sentence.
factors?
The two factors were the seriousness of this violation as it demonstrates a breach of trust, and the fact that this was a very similar crime to the one he had committed down in Alabama, and that it happened so soon after he'd begun his period of supervised release. And that is not adequately accounted for in the policy range, or the policy statement range of 12 to 18 months, because this is a mass, yes, he was a courier, but he's a courier for a massive quantity of cocaine. And it's in the transcript, it's in the joint appendix, that this is over $100,000, the purchase price, and that's not the street price, but that's the purchase price of this cocaine. So engaging in this very serious conduct, which is allowed and accounted for in Chapter 7 of the policy statements, that says the district court's primary focus should be the breach of trust, while taking into account the seriousness of the underlying violation and the criminal history of the violator. And that's exactly what the court did here in accordance with Chapter 7 of the policy statements in Chapter 7.
I'm glad you brought that up because I think Mr. Bryant, if not in his argument, but in the brief, someone mentioned the fact that the court didn't mention the policy guidelines statements. What are we to make of that?
Your Honor, it's clear if the district court does not say the magic words that he's considered the policy statements, it's clear that that was animating the court's decisions in this case. He mentions the breach of trust repeatedly, and is specifically when imposing the sentence, and exactly what the policy statements allow him to consider, and exactly what is present in the 3553A factors, the ones that are relevant to revocation. He repeatedly relies on those factors.
And so, but related to that, I guess the other thing he didn't mention, and correct me if I'm wrong, is an acknowledgement of what the guideline sentence was for this revocation offense. I think the government likely mentioned it, but the district court didn't mention it or acknowledge it. So, I mean, there's a lot of things that we would need to infer here about what the district court did, and I think that's the concern here.
Yes, Your Honor, and that's a legitimate concern.
Or understood, what the district court understood is
Yes, Your Honor.
responsibility.
So it is correct that the assistant U.S. attorney at the hearing put the guidelines on the record. The court processed those, excuse me, I said guidelines, I should be more clear, it's the policy statement range. Put those on the record, and then the court said that he considered that in imposing the sentence. I believe that's on JA 50 and 51, that he'd considered that and used the language saying that in considering the scope of the defendant's breach of trust was imposing a sentence of 36 months, which he said was sufficient but not greater than necessary. To the district court, that means that the only appropriate and reasonable sentence for the district court was a 36-month sentence, again, for the same two reasons that he says over and over and over again between the sentencing hearing and the revocation hearing.
Can I ask you about what happened in the first half of the proceedings involving the original offense? There was a statutory minimum that was imposed, and I think both parties decided to forego consideration of the 3553A factors, and the judge agreed with that. I don't think I've ever seen that before. It seems a bit unusual, but how, if at all, are we to factor that in, that the district court did not engage with those factors on the front end, and so didn't have the benefit of those factors to the extent that they were relevant on the back end?
Well, I do think, Your Honor, that the district court said that he had engaged with the 3553A factors, the underlying hearing. In fact, I think he said that it would probably take him 20 minutes to put his statement of reasons on the record. So it's clear that the district court did that in the underlying sentencing hearing. And 8 of the 10 factors at the sentencing hearing are relevant in the revocation context. So the fact that the defense waived the reading of those statement of reasons sort of undermines, it's not necessarily a waiver, but it undermines the argument that he didn't explain himself well enough when he offered to put that on the record in the sentencing hearing. And they're now disputing whether there was sufficient explanation in the revocation context.
Do you have anything further?
No, Your Honor. Thank you.
Mr. Bryant?
Thank you. Just a couple of points, very, very briefly. I want to say that this is a case where the government specifically asked for punishment, asked the court to consider a punishment factor, which I didn't mention earlier, but I think that just goes to show that to the extent there is any ambiguity in what the district court was relying on, for the government to say now is the time to punish him, and for the district court to immediately say, okay, now this is the price you pay. I think that that's the inference that we can take. With regard to the waiver of the reading of the 3553A factors at the original sentencing, I'll confess I've never seen that either. I think it was simply an indication that everyone agreed that 10 years was a sufficient sentence in that case. It also makes it cleaner in this revocation case what the failure was, because there certainly was no request for a waiver in the revocation context. And I've had cases with these sort of dual proceedings where there's new criminal conduct and an immediate revocation, and the district court will say, I simply adopt everything I said at the earlier proceeding, and carry that over. And that makes it harder to argue that there wasn't a sufficient explanation at the revocation. We don't have it here. It's a much cleaner process, so to speak, that, and makes the absence all the more vivid. And ultimately, I think what this comes down to is, in the new criminal case, everyone believed that the statutory minimum was a perfectly adequate sentence, and yet at the revocation context, the court thought that nothing less than the maximum would do. And there's that sort of internal inconsistency and illogic that I think at least needs to be explained, why the minimum was totally fine in the earlier case, but nothing less than the maximum would do here. And I think at least spell that out, at least connect those dots, is really all that we're asking for here. And like you say, I think process matters. I think hearing it from the court matters. And there are factors that the court can't consider, but unfortunately it did here. And that's why we asked the court to vacate the sentence and remand for a new revocation hearing. Thank you.
All right, thank you very much, Mr. Bryant. Thank you both for your able arguments this morning. We're going to come down and greet counsel and then take a very short recess before moving on to our third and final case.
This honorable court will take a brief recess.
in Fourth Amendment matters. The court said, "The Fourth Amendment does not freeze the frame at the moment a trigger is pulled. It demands assessment of the officer's actions in light of the totality of the circumstances. A court is not permitted to narrow the totality of the circumstances inquiry to focus on only a single moment. It must look, too, at any relevant events coming before." In this case, the district court did exactly what the United States Supreme Court in Barnes said was legal error. In this case, the district court focused solely on the moment that force was used, the very 3 seconds that Corporal Painter discharged his firearm and not a second before that. When we give careful attention to the facts and circumstances relating to the encounter, as required by Barnes versus Felix and Graham v. Connor, the following undisputed facts inform the reasonableness of Corporal Painter's use of deadly force.
Before you get into that, Ms. Seifert, why is it that we should do this analysis? Obviously, we're compelled to figure out exactly what to do in light of the Supreme Court's new instructions on how to look at these cases. But why isn't it first up to the district court to figure that out and then for us to review that decision?
Yes, Your Honor, a couple things. One, this is a qualified immunity matter, and under U.S. Supreme Court precedent, including Mitchell versus Forsyth, we know that it is important to resolve immunity at the earliest possible time in a case. It's not a defense on the merits, it's an immunity to the suit. So one of the reasons is we are here on motion to dismiss, and the material facts are settled. The court only has to look at the amended complaint, which includes the body-worn camera video, to determine those facts. So there's not a dispute of fact or any other sort of issues that have been presented through discovery that this court would need to review. So while the court, of course, does have the authority to remand the matter, it is appropriate to decide on motion to dismiss, even though the standard was applied erroneously by the district court. And
So are you asking us then to apply the Graham factors?
Yes, Your Honor, we're asking you
in the context of a harmless error analysis?
Your Honor, it's not a harmless error analysis.
Okay.
It's a de novo review on qualified immunity on this motion to dismiss. So on this de novo review, what we are asking the court to do is look at the amended complaint and the body-worn camera video that was a part of the amended complaint, taking those facts from the perspective of an objectively reasonable officer on scene, and determine whether or not Corporal Painter is entitled to qualified immunity. And as the court knows, there's 2 different prongs for qualified immunity. The first is whether or not the conduct of the officer was objectively reasonable and did not violate a constitutional right. And the second prong of qualified immunity is, of course, whether or not the right at issue was clearly established, because officers are only held liable for violating a clearly established right. In this case, what we're asking the court to do is truly what the Fourth Circuit Court of Appeals has always done. Consider the totality of the circumstances. What the district court did in this case, considering solely the moment of force, is not consistent with what this court has done in Fourth Amendment use of force cases in the past. The court
Right,
has,
so obviously we accept all of that as true, but, and there are circumstances and then there are circumstances, and obviously the moment that force is used is not irrelevant. Frankly, looking at this video, at least it seems to be pretty critical exactly what the officer was thinking and when he decided to fire. And of course, we don't have any testimony from the officer. We only have the complaint and the allegations of the complaint. So walk me through why you think the circumstances leading up to the shooting justified the officer acting at the time that he decided to act.
yes, Your Honor, of course. And as the Barnes court said, we don't put chronological blinders on the timeline of the totality of the circumstances. So we start at the beginning for the context, the historical context of this encounter, with the nature of the police response. There were 2 911 calls that there were reported breaking and enterings into 2 homes and 1 vandalism to home. And then it was relayed that the suspect had entered another neighbor's garage. So arriving on scene, the officers have the context of 2 breaking and enterings and a vandalism, which we know from Fourth Circuit precedent, for example, in Rambert, is sufficient to make officers aware that there is dangerous conduct afoot. In addition, when the officers responded, both officers were in uniform. It's seen on the video that their uniforms display them as police. The female officer is also in a marked police vehicle displaying that she is Chesterfield County Police. This is also important and critical to the context because in Fourth Circuit precedent, the court has always considered was the officer readily recognizable as law enforcement, or did they otherwise announce themselves? So in this case, when they're responding to the calls, they are identifiable from their uniforms in the vehicle as law enforcement.
Okay, do you have any Fourth Circuit precedent, though, to bring to our attention any case where the individual was backing away from the police and then turned, running away, and the police nevertheless shot him in the back? Do you have any cases like that that suggest that use of force is reasonable under the totality of the circumstances, that you can shoot somebody in the back who is running away from being apprehended for an attempted burglary?
Your Honor, there is no case that squarely governs that fact scenario in the Fourth Circuit.
Right, but do you
or the
have
present.
any cases that involve police shooting somebody in the back when there is a nonviolent crime that they have been responding to?
Well, yes.
And burglaries, no doubt, are very serious,
Yes.
but they're responding to a nonviolent crime.
Well, actually, Your Honor, under Virginia Code 18.290 and the code sections that immediately follow, though the crimes at issue here are actually considered violent offenses under Virginia law.
Well, it's a daytime burglary, yes?
Yes, ma'am, it is a daytime burglary,
Okay.
but the suspect is armed with a deadly weapon. He's carrying a hatchet, and he's exiting the home with a hatchet.
Right, but he was running away from the police when he was shot in the back.
At the moment that he was running, he's a fleeing felon, which under Tennessee versus Garner.
And you
allows-
have a right to shoot someone in the back when they're running away, you're saying?
Your Honor, yes, under Tennessee versus Garner. However, in this case, back to the first part of your question, Judge Keenan, in Caraway, a recent Fourth Circuit case by this court, the suspect in Caraway was taking a few steps backwards prior to the shooting. Now, it wasn't the 1 second beforehand, but it was in the few seconds immediately before the shooting. In this case, the suspect is walking backwards towards an intersection and towards homes. And I do want to back up for a second because we've skipped some context there. The suspect emerges from the garage.
Before you do that, so wasn't it the case in Caraway that the individual in that case appeared to be raising the weapon at the time that officers shot him?
Yes.
This was a firearm, not a hatchet, right?
That's
He was
correct, Your
reaching into his jacket to retrieve something, wasn't he?
That's correct, Your Honor. He was following the commands that had been given to drop the weapon, and the officers in Caraway had assumed that the weapon was in his hand. It was a phone in his hand, not a weapon. And when the suspect went to reach into his pocket to pull the weapon out, that's when the officers shot. In all of the Fourth Circuit precedent, it has been very important to this court that the officers are recognizable as law enforcement and that they give clear and consistent commands. And in this particular case, after the suspect has the hatchet in hand and turns and walks into the street, the officers have been giving clear and consistent commands to drop the weapon. And instead of dropping the weapon, the suspect looks at Corporal Painter and says, "Is that a big enough gun?" And then starts walking backwards with his focus on Corporal Painter as well as the individuals that are standing, the citizens that are standing behind him, and they continue to give verbal commands to put it down, and the suspect does not comply. These are not ambiguous commands, and the suspect continues to hold the hatchet, and he's not holding the hatchet dangling out to his side. He's holding it like this. He's holding it in a threatening position. This is a hatchet that can be used at any moment. It's not like a gun where you have to consider in Franklin, are they holding the barrel of the gun down or is the muzzle pointed down? This is a hatchet that can be thrown and used at any time.
No, sorry. Go ahead, Judge Keenan, go ahead.
In terms of reasonableness, why doesn't Wilson versus Prince George's County resolve that? You had a lot more compelling facts in that case, it seems to me. The officers were responding to the breaking and entering and assault. Suspect was holding the knife and moved toward the officer, which Mr. Byers was not doing.
That's
Did not
correct,
move
Your Honor.
So why doesn't Wilson versus Prince George's County, in which we said that the use of force was unreasonable. We later resolved it on clearly established prong.
Yes, Your Honor.
But we said that it was unreasonable. Why doesn't that establish the unreasonableness of the officer's conduct of shooting somebody in the back?
So the facts in Wilson are dramatically different from the facts in the case at hand when you consider the weapon and how it was used and the threats made. There were no verbal threats towards the officers in Wilson. In this case, we have the questioning of the big enough gun, and then 2 to 3 seconds before the deadly force, the suspect looks at the officer, and in response to him saying, "Put the weapon down," the suspect says, "Come get it."
But then the officer started shooting.
Yes, Your Honor, after the
And-
head turn.
And the defendant, no, I don't want to say defendant, excuse me, and Mr. Byers then turns and runs. See, I mean, for purposes of argument, let's concede the first shots to your position, but I don't see how you get over shooting somebody in the back.
But Your Honor, the shooting occurred all in 3 seconds. In Caraway, this court said, the Fourth Circuit said it was not going to parse a 3 to 4 second time frame because of the idea that the officers are responding in tense and uncertain and rapidly evolving environments. And I would like to go back to Judge Keenan Wilson. In the Wilson case, the facts were that the suspect had stabbed himself in the chest and slit his own throat and had asked the officers to leave so that he could do what he wanted and kill himself in front of his girlfriend. Here we have a suspect with a hatchet who the only individuals that are that he's wanting to engage with are the officers, and then there's the individuals behind him. There is no indication here that he wants to harm himself. His threats to the officers, "Come get it,"
But
are not
when
like
you
Wilson.
when you watch that video, it's quite clear that this man, this unfortunate person, he was disoriented. You know, his family, we have from the record that his parents lived nearby. He was wandering around. Obviously, he was breaking the law and a serious crime. But how does that then permit the police officers to do what they did?
Your Honor, it's because the information is based on what the officers knew at the time, what an objectively reasonable officer on scene would consider, and what the parents were going through, where they lived. That was not part of the record as to what these officers knew. They responded to a breaking and entering call ×2, a suspect with a hatchet who's ignored 15 commands. They tried the less than lethal force of the taser, and still he did not drop the hatchet. What message is conveyed to an officer other than this hatchet may be used against you by a suspect who does not drop it in the face of law enforcement and 15 commands, and then raises the hatchet, lowers it, twice says, "Come get it,"
Okay,
and
but
turns.
when you say raises it, he wasn't raising the hatchet so the blade was up. He was essentially moving his arm and elbow.
No, Your
up,
Honor, the
no?
video shows it like this. And that screenshot is
So
in our brief.
how far did the hatchet get up then?
Like this, Your Honor.
Okay.
But a hatchet doesn't have to be raised to be thrown or used. That's part of what is very different about this case than any other case that the Fourth Circuit or the US Supreme Court has looked at, is the type of weapon. Because if it was a
Can I ask you,
gun,
so let me ask you about that and something related to that. Is it your position that the officers would have been entitled to use deadly force at any point in this encounter,
yes, sir.
right from the very beginning?
Yes, sir. From the moment that the officers were out of their vehicle and the suspect had the hatchet and that he walks into the street and has already defied commands, at that moment, that was a deadly force encounter. And the only thing that occurred between that moment and the time that deadly force used was an escalation of conduct, insofar as the comments that Mr. Byers made to the officers, the failure to drop the weapon after 15 commands and a taser deployment, and then the comments that he made, raising the hatchet, repositioning it out to his side, the officer saying, "Put it down," and he says, "Come get it." And then he turns his head. And in Slattery versus Rizzo, this court said the turning of the head is a movement that can indicate that the threat is coming. So under those circumstances, immediately following those 4 seconds of conduct, Corporal Painter used deadly force based on an objectively reasonable perception that Mr. Byers was a threat with the hatchet.
And then what was the objective reason to shoot him in the back 3 times after he was running?
Your Honor, the suspect was running with the hatchet in hand, and was still a threat not only to the officers, but at that moment, he's also running towards the home in the intersection.
It was still a threat to the officer. How many times had been hit? 3 times, and then he turns, he's still running, and you shoot him in the back?
Your Honor, he ran for 5 seconds with a hatchet in his hand. He was still a threat
He was
to the people.
dying.
That's not what it appears on the camera when he's running with the hatchet in hand. He's still running towards the homes. And in that
He was
case,
running up the street.
Your Honor, I see that my time is up. May I finish answering your question? Yes, Your Honor, in Ricard versus Plumhoff, in Plumhoff versus Ricard by the U.S. Supreme Court, in 2014, the court said that when someone is re-engaging in conduct to flee, like they did in Plumhoff, that there is a public safety risk in that moment because of what the context is that they know about the prior parts of the call. So in this case, the attempts to break into homes and the having the hatchet, when he takes off running, there is still a grave public safety risk to those residences in the immediate area of the suspect with the hatchet.
Okay, but the complaint itself doesn't refer to bystanders. You and other residents, you do place some emphasis on that in your brief, but don't we have to look in this case to the complaint and to the video? And,
Yes, Your Honor.
And I don't see any bystanders.
They're on the video, Your Honor.
Where?
When
the video?
I can pull that up for you if I may.
Okay, well, I don't want to use your time now, if you could.
There's individuals cutting the grass on the right-hand side of the officer's video when they first arrive on scene, which you can see.
Right, but at the time of the shooting, where were the bystanders?
There were the individuals in the home
When the
that.
shots were fired, we actually see people on
No,
the video?
no, Your Honor. As the officers are giving commands, you see the individual cutting the grass, and then when Corporal Painter turns and is rendering aid, you see the 3 people that are on the video, you see the 3 people that are in the street. It's actually 1 second before the video that Mr. Curley submitted ends. You can see the 3 individuals that are standing back where the officers' vehicles are that had been observing the conduct. So those individuals.
Was that in the direction that he was running?
No, he was running towards the
He
houses on
was
Atkins.
running the other way, right?
Yes, Your Honor. He was running
Okay.
towards the houses on Atkins Road. Yes, Your Honor. I see that my time is up.
Thank you very much. Mr. Curley?
May it please the court, Paul Curley here on behalf of Margaret and Michael Byers. Your Honor, I think your questions that you've asked have squarely hit the nail on the head. Chesterfield County, the attorneys here in this case, truly believe that what Officer Painter did is okay under the law. They truly believe that. And I think this is how they are training their officers. They're training their officers. It's not necessary if somebody has a weapon to make a furtive or threatening movement. It's not necessary. You can shoot them anyway. If they don't listen to you, shoot them. And this has come out in the questioning that this panel had of counsel. They believe that at any time during this encounter with Mr. Byers, that it was perfectly fine that the officers gunned him down in the street. The Tennessee versus Garner case that Judge Keenan brought up, it's crystal clear that there has to be a threat to the officer in order to shoot him, to shoot the suspect. Counsel believes that Mr. Byers, who had already been shot, turned around, and Officer Painter pauses, aims, puts 2 bullets in his spine, killing him. That's okay in Chesterfield County. It's okay to shoot somebody who's not a threat to the officers. And this is the problem, is that Chesterfield County is training its officers that this behavior is okay. And that's why we have this problem.
Okay, but we're here on the qualified immunity.
I understand. Yes, ma'am.
And we have to talk about
But-
whether the use of force was unreasonable.
Yes, ma'am.
And whether the right, if there was a right, was it clearly established? So.
Yes, ma'am.
If you could keep us.
I apologize.
on that, that would
If
be
you
helpful.
parse through counsel's argument, what they're asking this court to do in this interlocutory appeal is to second guess the analysis of the record that was done by the district court, which of course this court can't do under the longstanding precedent in Johnson versus Jones. Court can't do that. This court has to take the record as it was given to them by the district court. And here's what the district court found. The allegations of the amended complaint, viewed in the light most favorable to plaintiffs, alone demonstrate that Officer Painter began to shoot at Mr. Byers despite a lack of provocation. Mr. Byers was not a threat to Officer Painter or anyone else, immediate or otherwise, when Officer Painter began shooting at Mr. Byers. Exhibit H, which is the body cam video, helpfully illustrates this critical moment. At the time that Officer Painter begins to shoot, Mr. Byers is backing away with both arms relaxed at his sides, holding the hatchet in one hand. Mr. Byers makes no movement toward the officer, and the hand holding the hatchet does not so much as flinch.
So, Mr. Curley, obviously, we need to consider that. That's very relevant. I don't dispute that. But now we've got the Supreme Court case that suggested that we don't start and stop there. We go back to the beginning of the encounter and decide whether those additional facts, or the district court, I suppose, in the first instance, whether those additional facts of record, undisputed facts, somehow make a difference. And what's your position on that?
Well, I mean, there's no indication if you read Judge Young's opinion that he didn't consider all of the facts.
Well, but
he
went out of
recites
his
all
way.
the facts.
He went out of his way to say that the case law in the Fourth Circuit was different. He said, unlike other circuits, this circuit at the time considers only the moment of the right before the use of deadly force, and not anything that happened before. And so he said that explicitly, didn't he?
He did, after reciting all of the facts from the case and saying he considered all of the facts.
But you know, I guess
what's interesting?
Well, I'm sorry to interrupt you.
Yes,
but
sir.
I think your position is that it doesn't matter.
That's
so
right.
Tell me why.
Absolutely. And in fact, this is a very interesting point, because Barnes versus Felix.
Well, and if I could piggyback onto that, your opposing counsel, Ms. Seifert, seems to want us to resolve this today. And are you saying the same thing?
Yeah, yet I think it's pretty clear that, well, first of all, this is a de novo review, so exactly how Judge Young arrived at his decision to deny qualified immunity, I don't think matters much anyway. However, let's look at Barnes versus Felix. Went up to the Supreme Court, 9-0, went back. Well, 7 or 8 days ago, the Fifth Circuit affirmed, it decided exactly the same way, because there was a threat to the officer in the case. And they opened up and said that it doesn't change anything. If there's a threat, then it's justified. If there's no threat, it's unjustified. I don't care how you mix it up. In fact, if you look back, and I've looked back at every single case, furtive movement cases, for lack of a better term, in every single case in which there is a furtive or threatening movement, qualified immunity has been provided. There is not a single case in the Fourth Circuit or the U.S. Supreme Court where there's no furtive movement that qualified immunity is given to the officer. And the district court's review of the record in this case, there was no furtive or threatening movement with the weapon. And so the law is crystal clear. It's been established for years. Wilson versus Prince George's County, certainly a case. Cooper versus Sheehan. Nibbs versus Momford.
Counsel, Chief Judge Diaz gave you, by his question, an opportunity to give a framework of this case. The point is, the question was to you is that, notwithstanding the moment that if you drew it back, is it your argument that it was nothing that would add anything that's a danger to the police officer?
There's not a single fact that we're concerned about. They never should have shot him at any point.
These are the cases where you draw back, for example, like 10 minutes before that happened, the person turned around wielding a weapon. And then they're still chasing him, and then they get out of eyesight, and then later he turns around furtively, and it's a stick of gum he pulls out and he's shot. Well, you can't say, oh, you shot him for no, you have to go back and say, yeah, 10 minutes ago he pulled a gun while he was running. The point is that here is nothing in the record that would enhance. He walked across there with almost his skivvies. I mean, unlike he had a heavy jacket, barefoot, skivvies, almost a t-shirt, comes out holding a hatchet. They're 25 feet away. As a matter of fact, he got further away from them. If there's escalation, the police officer creeped on it. I'm not saying police officers shouldn't do that, but I'm saying that in terms of danger, is that your point?
Yes, sir. And if you look at the moment of threat versus totality of the circumstances, where the moment of threat comes from, if you read all the cases, is basically to stave off the government-created threat. You know, that people are claiming, well, you know, the police didn't follow the protocol, and this is how they ended up in this situation. And that's basically, at least that's my reading of these cases, is that, and that was the issue in Barnes versus Felix. There was a question as to whether the police officer should have jumped on the hood of the car. That was the issue, you know, and so the plaintiff's attorney in that case, who had brought the suit, basically was alleging that, well, but for the fact that the officer jumped on the hood, we wouldn't be in this situation. And so that's what the moment of threat, that's where it came from, is so we don't question what the officer did before. So I was curious when that issue was brought up, because I just thought to myself, well, expanding the window doesn't help Officer Painter. How could it?
Well, they were trying to apprehend a fleeing felon. I mean, that's not, you know, just going after somebody drunk in public. I mean,
Your Honor, and if you...
Somebody's a fleeing felon with a hatchet, so
Yeah.
that elevates it somewhat.
I understand, but you know, when Your Honor calls Charlie Byers a fleeing felon, the hair on the back of my neck stands up. He was a mentally ill person.
The officers didn't know that.
Well, Your Honor, they should have, frankly. Barefoot, confused, obviously confused, indecipherable speech, you know, asking the lady who, if he could have a glass of water.
Once again, the officers didn't know that.
I mean, I understand.
And you have to engage with the record, and frankly, the record is not at all unhelpful to you, but the reality is, as Judge Keenan pointed out, they are faced with someone who's suspected.
And I totally understand that.
Right. So engage with that.
I have to be totally honest with you. When I first viewed this video, I wanted to see that. I mean, as you understand, this case started out, there were multiple defendants. You know, when I saw this video, I wanted to see something like that just to make the case simpler. But here's the problem. From the very beginning, after the shooting, Chesterfield County's story was, we shot him because he was wielding an axe advancing on officers. That story was out there for more than a year. His parents believed that Charlie...
He clearly wasn't advancing.
No. So the video comes out, we see the video. They file a motion to dismiss based on qualified immunity. The term furtive movement or threatening movement isn't brought up anywhere in there. The officer's interview, he doesn't mention a threatening movement of any kind. There was none. And the district court found that there was no furtive or threatening movement. And again, there is not a single case in the Fourth Circuit, the U.S. Supreme Court, where a court has held that the officer is entitled to qualified immunity without the suspect making a threatening move. I mean, there are lots of cases where there's no weapon and they make a threatening move and qualified immunity. I mean, I don't mean to simplify it this much, but it's almost as if furtive movement, qualified immunity.
Okay, but I don't hear you emphasizing the fact that they then shot him in the back.
Oh, yes, ma'am. I mean, that's...
I'd like to hear from you on that.
Yes, ma'am. Yeah, I mean, they certainly have a Waterman versus Batten problem. And the officers, there was a break in the sequence. There were 4 or 5 shots. Boom, 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 boom. You can see on the video, Charlie turns around, he's shielding himself, flinching. And the officer takes aim, there was a pause, boom, boom, drops him. Fatal shot was in his spinal cord. We know that. We've alleged that. So even if the shooting was justified at any point, which it wasn't, it certainly wasn't justified to shoot the man in the back. And then you see on the video that dying on the ground, bleeding out, they hog-tied him. They put his arms and legs behind his back while he's gasping for air. And this is fine in Chesterfield. It shouldn't be fine. It's not fine. And it's never been fine under any of the cases. Nibbs, Cooper, I mean, any of them. In fact, the city of Tahlequah case, that's how you pronounce that, the recent US Supreme Court case with the hammer. Again, hammer, furtive movement. He had the hammer over his head and he was coming at the officers. But the issue in that case was not, were the officers justified in shooting him? I think the issue there was that the officers hadn't followed protocol that got them into that situation. So, if you look at the...
Can I ask you about the second prong of the analysis? And you've rattled off a number of cases that I think may be helpful to you on one or both. But what is the best case that you have that in the unique circumstances of the officer found himself here, that it was clearly established that he could not use deadly force?
Wow, I would say it's a collection of all of them, but Wilson versus Prince George's County, I would say, is pretty good. Man with a knife.
A man with a knife who was inflicting injury on himself.
Only on himself.
Right, so that's not really on all fours, is it?
Well, it's not, but you've...
But he was moving toward the officers.
So that's a little bit different.
Yeah.
The nibs, there are just so many of them. Casella versus Hughes, I think, is pretty instructive.
What are the facts of that case?
That's the mentally ill woman had a large kitchen knife, moved towards her roommate and was shot. The officer believed that she had taken a threatening or furtive movement toward her roommate and was going to harm the roommate. Shot.
So there was qualified immunity granted there?
Yes, and it went to the U.S. Supreme Court.
That's not helpful.
Well, I think it is, because you take away the furtive movement, and I don't
know that is it the law that an officer has to wait until a furtive movement occurs before he can use deadly force?
Absolutely.
What case says that?
Nibs, Cooper.
Those are cases involving furtive movement. But
Hensley versus Price.
You're not answering my question. Those are cases involving furtive movement. Does the court say it is required as a matter of law for an officer to see furtive movement before he or she can use deadly force?
Yes, sir.
Where does it say that?
In just about every one of those cases, Ailman, and I'll read it. The failure to obey commands by a person in possession of or suspected to be in possession of a weapon only justifies the use of deadly force if that person makes some sort of furtive or other threatening movement with the weapon, thereby signaling the officer that the suspect intends to use it in a way that immediately threatens the safety of the officer or another person.
Okay, Ms. Seifert,
clearly established
right.
July 2023.
And Ms. Seifert points to the fact that Mr. Byers in this case was holding the weapon, she claims, at the ready.
Absolutely untrue.
Okay.
It's on the video. And again, so what she's asking basically is that you second guess the analysis that Judge Young made of the video. You can't do that.
Also, in second guess what we could see for ourselves in the video.
Right, it's there. For her to represent in this court that he had the hatchet like this is dishonest, Your Honor. Didn't happen. At the very most, I think he looked at it. He turned it and looked at it. That's it. And I'm thinking to myself, what am I going to do 25 feet away with a hatchet like this that is a threat to anyone? What are you going to do with it? There's no threat. And any objective, reasonable officer would know that there's no threat. Chesterfield's trying to get this case dismissed at the motion to dismiss stage. They don't want to go through discovery. They don't want a jury to hear this case. So they want to get it knocked out like this. And the court can't do it because Judge Young has already established the record. You can't second guess his interpretation of the video. And he says there wasn't a movement. Just to add the emphasis, he said the hand holding the hatchet did not so much as flinch.
Well, we can see the video.
I know. And it's true. He at the moment he shot, he has the hatchet like this and his head's like this. Threat? Of course not. When he's shot in the spine, his back is turned, he's like this. Threat? No. No threat. Therefore, no qualified immunity. You can't have qualified immunity without a threat to the officer. I don't care what legal test you use. No threat, no qualified immunity. It's not any more complicated than that. Every single case, there has been a objective, reasonable threat to the officers, and I totally understand the use of force under those circumstances. Not these circumstances. There was no threat. I could go on and on, but if the court has any more questions, I'm happy to answer.
Thank you, Mr. Curley.
Thank you, sir.
Seifert.
First, let me take a moment to address the comment that what I have represented to the court was not accurate and was not true. We have provided in our brief, and if you look at JA 158, 632 to 633, the very moment, 3.5 seconds before the deadly force was used, the position of the hatchet. So the court is able to view it, of course, that is part of the record. On a de novo review, the court has the opportunity and ought to be looking at all of that context, as the court in Barnes has told us. The behavior of Mr. Byers observed by the officers on scene is what is at issue here.
Non-compliance, that's what it was.
Your Honor, it's non-compliance, and it's with a hatchet, a deadly weapon in hand, with the knowledge that 2 attempted breaking and enterings and a vandalism to home had already been completed. And Mr. Curley has conceded, citing Casella versus Hughes, that the law on this type of matter is not clearly established, because that's what the United States Supreme Court held in Casella. Qualified immunity because the law was not clearly
It
established.
is clearly established. It doesn't have to be exact. That's why you don't have any cases like this where someone is shot in the back.
Your
In the
Honor-
back, and you get qualified immunity.
Your Honor-
Because it's obvious for the police officers, most of people, I mean, common sense would be, you don't shoot a person in the back after you've shot 3 times, and then they're turning around, literally dying, and you shoot them again 3 times?
Your Honor,
I
Mr.
think anyone
Byers
common
was,
sense would know that in terms of, you can do that.
Mr. Byers was still holding the hatchet at shoulder height when he was shot. In the Caraway case, there were 3 shots while the suspect was kneeling and 12 shots after he fell to the ground, laying prone. And in the Caraway case, this Fourth Circuit said it all transpired in 3 to 4 seconds, those shots.
Right, but there was a gun pointed at the officers when they opened fire on Caraway. And in this case, the police shot this man in the back. How do you get around that?
Because, Your Honor, the officer starts firing as the suspect got the hatchet in his hand and has
Right.
just said, "Come get it," and turns. And then the suspect.
Right, and once he starts running away, turning, you have a right to shoot him in the back. Why? You've never answered that for us here today.
Your Honor, he is a public safety risk, as the United States Supreme Court recognized in Plumhoff versus Ricard, when he chose to flee with the hatchet. But also, this happens in a matter of seconds. The shots fired all took place in 3 seconds. 3 seconds that the officer has to perceive and react. In this case, it was 3 seconds. And when he turned, the officer believed there was a threat to him and then a threat to the others with the hatchet still in hand. This is not like Wilson, where the suspect is only a threat to himself. And, Your Honor, in the Wilson case, this court wrote how to clearly establish law. This court wrote
But Wilson, the suspect, even though he had injured himself, he was moving toward the officers with the knife.
with a yes, ma'am.
With the knife. In this case, the decedent was not moving toward the officers. He was running away from them,
Your Honor,
backing away.
at the
The
mo-
whole time, he never was advancing.
at the moment force was used, the officers were facing a suspect with a deadly weapon, a hatchet, which has never been considered by this circuit or the US Supreme Court. And they used deadly force because they perceived reasonably that hatchet to be a threat. Why else did the suspect not drop the hatchet? What other perception is reasonable to an officer on scene when they've given 15 commands? The law is not clearly established on this point in the United States Supreme Court or by the Fourth Circuit on how to handle that situation. In Wilson, it was clear it was a stumbling suspect who stabbed himself.
You know, we see this so often in our case law, in our cases that come before this court. I've been listening to these cases for a long time. And so often when somebody has a mental problem, and I know this record doesn't elaborate on that, but so often when you have somebody who is not without those kind of problems, the police don't know how to react. And it just screams out for more training in mental health situations. It absolutely does. That's aside from this case, but you know, to the extent that you represent Chesterfield County, you may want to send that message back.
Yes, Your Honor, I see my time is up. May I respond?
Yes.
Yes, Your Honor, I appreciate that. And this is, of course, a tragedy. And these officers were not aware of his mental health condition based on the record and the way that this occurred. And for the law to be clearly established, I'm going to wrap with a quote from Atkinson versus Godfrey. This court said, "We do not decide whether a right is clearly established like a customer in a buffet line, selectively picking items and declining others to come up with the ideal meal. The reason for this should be clear. The second prong of qualified immunity examines if the law fairly warned an officer that his conduct violated the Constitution. Mixing and matching parts of dissimilar decisions does not provide the requisite fair warning." And Your Honors, in this case, opposing counsel stood before you and said that there are a few cases that you can piece together that would clearly establish the law for this. Casella versus Hughes from the US Supreme Court has said that the law is not clearly established in this type of situation. And for those reasons, we would ask that you reverse the decision of the district court, find that Corporal Painter is entitled to qualified immunity. Thank you, Your Honors.
Thank you very much, Ms. Seifert. I want to thank both counsel for their arguments in this very difficult and emotional and challenging case. We'll come down and greet you and then go into conference, and then when we're done with our conference, we'll come back and entertain questions from the students at the law school. So, Madam Clerk.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.